2, 3, we're all here, are we all? Right, first and foremost, let's make you introduce myself because I think I know all of you guys here, okay? So I'm preaching to the converted. Secondly, I'm not here saying to you that I'm a man who thinks this or thinks that. I'm only dealing with experience, yeah? And I try to give my experiences to other people so they can use it and think, okay, you know, I mean, look, you can do a PlayStation game and think you're the world's best Formula 1 driver. But it's not until you get in a Formula 1 car that you know what's going on. And if you get a good researcher like Rob, and I've had Rob and we've had Lance talking about stuff they deeply researched. If Rob says to me that something's absolutely on the bullseye, I will challenge it and do it, although I don't believe anything, unless you know, I personally experience it, but I would do it and test that experience out. So we've had some very good information brought here today, and you know, and I'm glad to see there's as many people as there are. They usually chuck me on at last when I've had too much to drink, so that's the way. But that's just the way it is. Right, okay, so maybe you're going to have a bit of a breach of the peace later or something. So I've taken some notes about what people have said earlier, so I'm going to try and refer to that from my own experiences, right? So we'll go through that, and then we'll go through a couple of points, right? Right. First and foremost, you know, I keep getting told that, you know, nowadays, you know, we know the score, right? Nobody takes accountability. Nobody takes responsibility. But we also hear that nobody is above the law. So maybe it's best to be nobody. Nobody's above the law. So I mean, he hasn't got a problem, has he? So that's interesting, and that was brought up, right? Now, when Rob was saying about void and voidable, that's exactly right. What's voidable and what's void, they will always tell you it's voidable. Voidable, you know, oh, we've made a mistake on that document, it's voidable, right? But it's not, it's void, yeah? So, and of course, to be insured or have an indemnity, you cannot have insurance or indemnity for two things. One, to commit a crime, and two, for an act of God. So you've got them nailed on those areas, yeah? We know all this stuff's false. We know the civil courts are criminal enterprises operating against us, and this is why I've, you know, for many years, you know, I've been involved in this. I was involved, right, from 1978. I've been involved in the criminal law, right? Okay, you know, for want of a better word, yeah. I realised I shouldn't, as a very young man, I realised I don't want to rob my fellow man. Anyway, if you've got loads of money, where do you keep it? In the bank? Oh, I'll have that one in. That was the way I used to look at things. And so I didn't try robbing people, I tried robbing the banks, yeah? And that was what I did. And I'm not, you know, I'm not saying that was a good thing, but that was what I did. So I've had 38 years court experience, but that's experience. Doesn't mean I'm right, it doesn't mean I'm wrong, it means I've had experience in these issues, and so I'm able to tell people from first-hand experience. And if you can listen to what I've got to say and then think, well, okay, that happened to him, maybe or maybe not, because we're now dealing in lawless times, yeah? And I call it casino law. If I was going to set a company up, I'd call it casino law. When the chips are down, come and see me. You know what I mean? That appears to be where we are, you know. The criminal law and the civil law. Now these are two things that people get mixed up in, because I know most good people have never been involved in the criminal law. Don't know nothing about it. But the criminal law has got, always had checks and balances. If you were charged with something you shouldn't be charged with or whatever, there were checks and there were balances throughout the old 80s, throughout the whole 90s. So again, I'm not trying to sort of like say to you, you know, I've been found not guilty on 34 offences in my life during the 80s and 90s. I've had no case to answer on 20. Right? So you think, well, okay, what does that mean? Well, what it means is this. We've got checks and balances in the criminal law. If you put any of those cases into the civil law, which I've been dealing with since 2005, since my father died, then I'd be found guilty of every one of them, and I'd probably be doing 100 years in jail. That's, you know, because we're dealing with a criminal enterprise where there are no checks and balances. So recently I've found myself assisting people in criminal trials. where they've been overcharged. Now, this sounds bizarre. Some people think, oh, well, whatever they've been charged with, they've been charged, they must be guilty of it. Let's get it absolutely right. All these civil cases, and the only way you can get a civil case sorted out is by turning it into a criminal case and then getting a jury and getting a jury to make a decision. And that's where we have the Rooftop 7 with Mark, etc., and Craig. That sorted that out. We've got no law in the civil law. There is no law. They don't even give you the correct documentation. Nothing is correct. So the only way we can turn things around is by turning the civil into criminal and reflecting, as Rob was saying. And that was a very big part of the case with the Rooftop 7. Because, as an example, it was wonderful. I've never been, in all my 38 years of experience, I've never been to a trial where more than one person represented themselves in a Crown court. So please, anyone involved in the civil courts, put that to one side. The Crown court in front of a jury. And I've been on trial with 12 other people at the Old Bailey. And one person represented himself and caused havoc, right? And that's where a lot of the information I've got, I'm respectful to the guy, and his name's Eric Allison, and he's the prison correspondent for the Guardian newspaper now. But in those days, back in the early 90s, Eric was a serious dude. And when he could come to halfway through the trial, he realised that his barrister couldn't represent his interests, so he represented himself. And he took that court apart at the Old Bailey, and we had News of the World. It was their crime trial, because I was involved with a prison officer. They said, what they were saying was that I was involved in a conspiracy to defraud the United States Treasury with a prison officer from Gloucester Prison. And I was involved in conspiracy to supply 1,000 stolen British passports. This is in 1990. And this guy had his barrister there, tried to fight it all the way through, and at the end of the prosecution case, he wasn't able to get no case to answer, and I'll say that again to you. No case to answer, and because the barrister wasn't able to apply that, he represented himself. Every one of the defence barristers came to me individually and said, I mean, Eric's 20 years older than me, have you got any sort of influence over Eric? Every one of them said, listen, any man who represents himself has a fool for a client. Every one of them said that to me. And of course, I had no influence over Eric. He was, you know, older and far more senior than me. But Eric tore that court apart. And when we were all stood there with all our barristers for 2 months, some of the shenanigans that went on were amazing. After 6 weeks, the case was supposed to be heard within 6 weeks, and it had been all over the News of the World, front page, centre spread in November 1990. And it was a big case. It was called Our Crime Story. And they said that we were involved in counterfeit money, Libyan terrorists, and the IRA, and it was all absolute nonsense, based on a man who had got out of prison, a prison officer had got him out of prison, and he had then gone to the News of the World and set everyone up with the International Organised Crimes Branch. And of course he tried setting me up along with a lot of other people, and it didn't work. But when we were in court and Eric represented himself, it was amazing. And I saw it with my own eyes, because I had a barrister then, and I sat there for 2 months. And when you're in court at the Old Bailey for 2 months, and you sit there, the jury come in every day, and you get to know them because they're in every day, and you know, you're chatting to them, and the screws, and all the rest of it. And when this went on over the period of time, Eric was militant then, because he was stood with the barristers, he wasn't in the dock with us. So after 5 weeks, they said, the case was only supposed to go on for 5 weeks. We now have to have an extension, and they want an extension. And why do they want an extension? Because if a case goes on for longer than 4 weeks in the criminal realm, they get a thing called a refresher. Now a refresher is, if you're all the clerks and solicitors and I'm the lawyer representing someone, after 28 days, our mind in court, our minds go numb. Our thinking time, you know, the only people who can get thinking time are lawyers. If I claim to be thinking about something, I can't charge you for it. If I'm on the toilet, thinking, oh, do you know something? The reason that carburettor ain't working is because of this. I don't get paid for it, but they do. It's called thinking time. And Eric ripped the whole situation apart. So on one example, I mean, one of multiple examples, the judge said after 5 weeks, I'm not able to come to court now because the case is only due to go on for 5 weeks. And every Friday I'm busy on a course. Any objections? And it went like this. No objection, my lord. No objection, my lord. No objection, my lord. All the way along. And they come to Eric and they said, Mr. Allison, and he said, well, you haven't told us what sort of course it is, my lord. It could be a golf course. And of course, the whole place fell about. But I mean, what happened? The jury started laughing. Then we started getting humanity into the situation. Now, under those circumstances, none of us, the people I used to associate with, and look, I'm no different to what I was then. I just look at things differently, as we all do as we get older, right? None of us had said anything. So there was a large group of us from all throughout the United Kingdom. We were arrested into this, and it was very serious, and it went, you know, it was all throughout the papers. But the core group of us hadn't said anything to the police, which I suggest that nobody talks to the police under any circumstances. If you tell me you had a holiday 3 years ago, you're telling them something they don't need to know. But that was what happened. And so we'd gone through the old style committal, which is very important to what I'm saying. Because under the old laws, we had checks and balances. Until Tony Blair got into office, we had a thing called an old-style committal. Again, criminal law, not civil, not your council tax, I appreciate all that. But I'm looking at holding the highest standard of evidence in the criminal. And anyone charged with a criminal offence that was indictable. Now, indictable means goes to Crown Court. Now, some things are summary, which means they stay in the magistrate's court. Motoring offences, unless it's drink driving or driving while disqualified, they stay in the magistrates, and they stay in the magistrates summary offences. Or they become indictable. Burglary, armed robbery, murder, they're indictable. You have either or offences, which are in between, which sort of, where they're trying to murky the waters and create corpus juris. But ultimately, it's either indictable or non-indictable. So, what happened in those circumstances? If you were charged with an indictable offence in the 1980s, burglary, theft, shoplifting, which is a theft, from 1968 Theft Act, you were entitled to a jury of your peers. And before you went for the Crown Court and that jury, they had to put you into the Crown Court. So you had to be charged and indicted, and they had to put you in the Crown Court. What happened was this: you were entitled to examine the evidence. Examine the evidence, not say, oh well, look, I was there, this didn't happen, that didn't happen, I don't know. No, what are the prosecution bringing against me? Okay, I'm not making any statement at all. I'm just going to examine if there's a prima facie case against me. And if there was no prima facie case against you, the magistrates would kick it out. That didn't mean you were found not guilty. It meant that there was, at this point, there was no evidence. And they had to go away and find more evidence. So throughout the 80s and throughout the 90s until 1996 was the last one of these that happened to me, I had 20 of these. Okay, so the magistrates booted it out because, as Rob was saying, liability is attached to all these things. And this is where we go back to Mark's case and Craig's and the Rooftop 7. Because when I went there and helped and I tried to do a court strategy with Betty and Mark and everyone else, you could clearly see that they were charged with conspiracy to commit criminal damage. Now, if you'd taken away that conspiracy element and put to one side, they're charged with criminal damage. Well, the criminal damage was under £5,000, it was a summary-only offence. It's only the fact they put conspiracy and attached that to it. Now, conspiracy is the hardest charge in law to prove. Okay, but it's the easiest one to get charged with, because they'll just charge you with the worst charge and hope something comes down from it. The problem being for them, and I say this to you all, this is correct. What's happening now is we haven't got committal proceedings in this country. You go to a magistrate's court, and I've been helping people all over the country, and I've discovered that they're charged with the most heinous offences, even though they've admitted what they've done. So, for instance, someone who's grown, example, 9 plants of cannabis himself, have been charged as part of a commercial enterprise involving a much bigger thing. And they're a little wheel in a big cog and all this, right? Okay? And they're charged, and they go to the Crown Court, charged with an offence that they haven't committed. Now, it hasn't happened. Now, I think it's outrageous if anyone pleads guilty to something that they haven't done. But I think it's completely outrageous if the offence hasn't even been committed. Think about it. You're charged, you know, we've done a shop, myself and Salon have gone down to the local newspaper shop and we're drunk and we've nicked a Mars bar. That's all we've done, put it in our pocket. And the police come bursting in, tooled up, and they say, armed robbery, the guy said you pulled a gun on him. Who would go to court pleading not guilty to that? Not guilty. You're taking a piss. It hasn't happened. There is no case to answer. Now, the criminal standard for no case to answer, which, if anyone's interested in what I'm saying, is Galbraith, right? That is the entire situation under the criminal standards is Galbraith. Very tight, very secure, no case to answer. So in the Rooftop 7 case, and I'll use that as a brilliant example, because we've had some wicked results this year. Okay, wicked results. The situation there was this. Mark and Craig Crawford said no case to answer. The other 2 guys who were representing themselves didn't say, they said not guilty, but they held true to what they were saying, and the other 3 were represented. And I knew, I've never seen a court of law in this country where more than one person unrepresented is in court, because the whole thing gets thrown into chaos. If there's more than one of you on a criminal, and we're talking criminal charge, and you aren't represented, and you represent yourself, right? Because at any time, you could create a retrial. You could say what you want, do what you want, and all of a sudden, oh, retrial. Now them guys were in for what? Criminal damage for a window. Let's get serious, right? But because it's got conspiracy attached to it, it was allowed to play out. So in the initial phases, Mark and Craig stood firm and said, no case to answer. So what happens? This is what happens. This is what used to happen under an old-style committal. Under an old-style committal, the evidence would go, the committal bundle would go to the magistrates, and when it got there, it would have a little pink bow tied around it, because whatever's in there is evidence, and that is the evidence. They'd untie it, and they'd say, right, no case to answer. All the statements of the prosecution, all the prosecution evidence, would have to be read out inside the court. The defence then could question what was going on, make a statement about it, and then declare no case to answer. There is no case to answer. Now, in 1996 or 7, Tony Blair and his government said that this ancient process, right, it's called Old Style Committal, section 116, I think you'll find out that it's called, was only being used by terrorists and gangsters. Basically people who kept stum, don't say anything to these people. But they're the ones bringing the case. And like Mr. Ebert says, right, a judge is just a bellboy for the court. He carries the cases around, doesn't he? He's a bellboy for that court. That's all he's doing at that phase. And of course, you could say no case to answer at the magistrates' court. If the magistrates then decided, well, we think there might be a case to answer, we'll allow it to go through to the Crown Court. And you went to the Crown Court, you could still say, no case to answer. The judge would hear submissions. This is your second part of the judge. The judge would hear submissions of no case to answer. And he might then say, well, based on this, you know, there isn't much. This is what they said in Mark and Craig, in Betty's case. There isn't much, but I think there is a case to answer. So you'll now enter pleas of not guilty. And Mark and Craig said, no, there is no case to answer. So he got very cross, and said, at that point he said, well, I'll enter a plea for you. So he said, I don't care. So I civilly said, sounds like it. And he went, and started barking at me at that point. But there was no case to answer. Now, you imagine in that case, and I use that case as specific, if at the end of the prosecution case, when the prosecution say, and that is the case for the prosecution, my lord, they would have then jumped up yet again and said, no case to answer. And the judge at that point would have said, actually, well, I think there might be, and allowed it to go through. But if it had gone through to the jury, 12 people of reasonable standards, which is what the Ghosh test requires under criminal law, people of reasonable standards think there is a case to answer. At that point, if he had said the case could go further, and the jury had ultimately come out, because Mark and that said, look, we're not even offering a defence. This is bullshit, no case to answer. And the jury came out and found not guilty. That judge would have been up the creek without a paddle, and Judge Fowler would have been retired on the spot. Because he's made a legal determination, the CPS has made a legal determination, but it doesn't apply common sense. Because the common sense is they said there's no case to answer, and the jury have confirmed that. Yeah? And this is very, very important. And like I said to you about the previous case with the Old Bailey with Eric Allison, you know, Eric Allison did one amazing thing. Again, you know, I couldn't believe it as a defendant in that case, because I was at that time, in 1991, I was trying to defend my position. But none of us had said anything to the police, so we said nothing to the police, which I don't say anything to the police if it's criminal. You don't need to. Let them present the case. And Eric had said nothing to the police, but when he was in court, the judge dismissed count 2 on the passports charge, but continued with count 1. So when Eric had his first thing he said, members of the jury, the judge has told you to find me not guilty of count 2, which you've done, based on a technicality. Not because I didn't do it, because I did it. I did count 1 as well. But I want you to find me not guilty, give me a perverse verdict, because this is all bullshit and we've been set up. That's what he said. And let me tell you, after 2 months on trial, when I was found not guilty, there was a group, the jury went out for 3 days. 3 days. On the second day, they kept asking what the interpretation of conspiracy was. He was found guilty by a majority decision, because they couldn't make their mind up. Now he told them, I'm guilty, but I want you to find me not guilty. And this is where we are. If a law is shit, the jury sorts it out, not the judge. That's why between 1920 and 1933 in America, we had the prohibition laws, you had drinking. And we'd have all been nicked. And they'd come in here and then you'd have these Muppet order followers breaking the barrels and all that. And we'd have all been guilty. And our families in the future would have thought we were terrible people for having a drink. Yeah? No, it's an unenforceable law. And all the juries were there, sat there, finding everybody not guilty, no matter what the evidence was. That's why it went away. Right? And that's why a lot of the stuff we're talking about, council tax and that, it's not even on the map, yeah? But it's got to go away. Yeah? So my experience has been through the criminal court. So what I'm saying to you is, you have different things going on all the time in the civil courts. They make it up as they go along, like Rob was saying. You know, what do? You're sat in a group of people and they don't listen to sense, they don't listen to reason, they make it up as they go along. You can read every rule, regulation, everything you want. They don't care. They're failed solicitors. That's what they are. If you go into a district court, they're failed solicitors. They've got a little job there for 16 or 19 days a year. That's it. But I'm talking about the criminal court. And what we've got to do, what I try doing, and I've had many, many failures, right? And that's why, but every time it's like giving them a spade because you just dig a bigger hole. And they keep digging, they make a bigger hole for themselves all the time. They can't bail themselves out. It's impossible. Impossible to bail themselves out of the situation at the moment. Everything they're doing is wrong. You'll have one judge say one thing, one say another, and the criminal case of Mark, I wasn't expecting this inside the criminal courts, because I expect this in the civil courts, so you just make it up. Yeah? I wasn't expecting it in the civil courts. And when the judge was there saying, oh, I said this, and then the audience said, no, no, you didn't. He's like, hang on. He's like, oh, no, you didn't. Oh, yes, I did. You know, and all this is on the court record. It's not, you know, we're not dealing with the civil courts now. We're doing the criminal courts. And who would pursue a conspiracy to commit a criminal damage charge under 5,000 or under
2,000.
Yeah, under 2,000, but it's not even a couple of £100.
We asked him how much the value of the damage was in the end, and the guy that worked for UKR said 2 grand. 2 grand for one window, apparently.
Yeah. And he kept saying, reflect, reflect. But the whole time, that judge was conspiring with them, and apparently, you know, there's a very good guy, what's his name in the Coventry court, who goes there and sits there and says...
Oh, yeah.
And he said, he's never seen this judge so confused with what's going on. But that's what we've got to do. Because at the end of the day, every time they open their mouth in there, they may be setting a court precedent. Now, when we talk about ID, ID is essential. Right? It's the ego and the id. Right? If you look in Greek, it's the ego and the id, and it's the id entity. That's what the id entity is. It's the identity. And what Rob was saying about it was, you know, I mean, absolutely correct. So, let's have a look at identity. Right. How do you prove who you are? Look, we've got films and cameras nowadays.
I'm here.
Well, yeah, great. But shall I tell you what, right? Is that where you are, Paula? I'll tell you what. I think we're here. I think we're in Nottingham. Right? Do you know what? If I asked all of you guys in a year or two's time, there'd be a few who say, oh, didn't that happen in Coventry? Didn't that happen in Leicester? If we had 5 or 6 years, I can't even remember it. Yeah? It's all illusory, yeah, okay, and it's all locked down in a time and place. So, when people are talking about the fruits from the poison tree, this is essential to criminal law. That's what confiscation orders are all about. They're the fruits of the poison tree. Mark's got 100 cannabis plants growing in his loft, which, I'm sorry, and we're all buying it off the end.
Tomorrow then.
Edit.
What are we all doing now?
And we're all up to this stuff, whatever. And any money that you've received is fruits of the poison tree, right? So that's essential. That's essential in criminal law, because that's what confiscation orders are. And what I've said to you there is they try to make out that you're guilty of a charge that you haven't done. So it's in America they call it step in the shop. Don't they what they call it?
Jump in the shop.
Jump in the shop. Jump in the shop. So the guy's is guilty of something. Let's charge him the biggest lump of shit we can, and we'll hold him to effective. Right? Well, okay, then you're not going to plead guilty or not guilty. You don't plead not guilty, just stuff like that. Don't plead not guilty. You plead no case to answer. Now this is very, very, very important if you're in the if you unfortunately find yourself in the criminal courts, and you may do, because if you're holding lawful rebellion firm and hard, you might find, like myself, I went back and recaptured my property back. So they charged me with a criminal offence. They knew damn well not to charge me with an indictable offence, which is what I wanted. I wanted to go in front of the jury and say, hello, members of the jury, here we go. Right? But of course they knew that, so they kept it summary. Okay, so that's part of the gatekeeping exercise, which they're all doing. Yeah? And the same faces will crop up time and time again, the same judges, the same clerks, the same shit will crop up. Because that's part of the gatekeeping exercise. Yeah? These people are either criminals, which most of them are, or they're cowards. You can tell this by looking them in the eye. The moral high ground's gone with these people. So, you know, when you stand in court and you look at these guys, you can tell straight away, listen man, you're a crook. You know, we know you're a treasonous bastard, but you might have had a lawful excuse that you didn't know what you were doing and it was ignorant. But you haven't got that excuse. I've informed you. I've given you full notification. So why are we here? So, move on.
Guy, just would it be fair to say to people that if you plead no case to answer, you're going to have a stand-up argument with the judge?
Massively.
Because he's going to say you've got to put in a plea.
Massively.
And you've just got to say, no, I'm not.
Massively. Well, we're getting this all over the country.
Batter them down over it.
No, that's a good point, Pete.
Just one other point. When you were in Wales, one solicitor pleaded
where, and Peter was in there long before me, because I was like arguing with the barristers and things, that when I came in, on another case that went before, the judge was saying, you know, this is first law students' indictments. They're not even written correctly, because it's supposed to be to the letter of the law.
Yeah, he said, he kept on saying that these indictments were wrong in law, and he slagged off this CPS barrister for about 20 minutes, lecturing her on the fact that they're incompetent and they spent all day having to mess around with CPS documents.
Because we're dealing with the clown prosecution service.
Yeah,
Okay, this is what it is.
The picture, it should have been filmed.
Yeah, we know all these people are greedy people, and we know they're whatever, okay? You don't go working for the Crown Prosecution Service unless you're bottom of the rung. I mean, seriously, because you could be a civil lawyer earning £400 an hour, why would you go to the Crown Prosecution Service? And because they think they've been given a licence to commit crime against us, and that's what's going on. And of course, you know, ultimately, you know, amongst the many cases, I've had someone who's gone to court and they just not turn up. Now, you know, and I know this goes on all the time, but it's a criminal matter. And if you go there and they don't turn up and nobody turns up, then your bail has expired. So you're no longer on bail. If they've not got an indictment, you're not indicted. The whole thing goes away. Okay? I mean, you know, it doesn't go away unless you fight it. But what I'm saying is, and the judges are sort of getting a grip of it. Even like with your case, Mark, Fowler, right? He's a gatekeeper proper, but he was making so many serious judicial errors throughout the case. You know, oh yes you do, oh no I don't, all this bollocks. And it went on for a week. A criminal damage charge went on for a week. Now, I'll move on, let me go through this because I'll move on to when I got arrested recently, right? Right. It's an interesting point. I posted something out the other day. I found that now they've made some big ruling that barristers must speak English. Right? Well, okay, that puts legalese at the fucking spike, doesn't it? You know what I mean? But barristers must speak English now. If you don't speak English, you can't be a barrister in this country. So I actually put, and in fact I've got like 2 or 3 barristers follow me on Twitter when I put that out. When I said, because, well, legalese is gone then. So, again, I've just made these moments, because I mean, what I try to do with people is I try to give people, look, I've been, and again, I say this stuff, but I've been at the Old Bailey doing 5 years in prison, dragged every day from Wandsworth Prison to the Old Bailey, you know, every day for 2 months, looking at another 10 years. Another 10 if I was found guilty. And it's frightening, okay? It's more frightening. But you get what I've heard of called the Toto moment. The moment when the little dog whips the curtain back and you can see the guy pulling the lever. Yeah? And, you know, I had that with Eric Allison, the guy I've explained to you. And I had that, and I was so honoured to be with a guy who was that brave to do what he did. But I saw that all these chaps in their wigs and their gowns, they had no effect against him. So, you know, rather than try and belittle myself in some ways, because when I go to court and I try to represent people, and I've done it in Rob's situation of saying an advocate for fundamental freedom is the one, they're very confused when you say that. That's what I'll say to you, okay? When you say you're an advocate for fundamental freedoms, they don't want to play them, okay? So I go in there saying that, rather than saying that I'm a Mackenzie friend or whatever, and I've done all that, okay? But that causes a big problem for them. You know, advocate for fundamental freedoms, you can see that they're reaching into their minds, just how do we deal with that? But what I do say, and I've had barristers recently working for, because I mean, I'm engaged in a lot of the criminal cases I'm involved in, which I'm more valuable in a criminal case, because any civil case, I virtually guarantee you, if you've got a civil case and you want to kick down the road for 6 weeks or 4 weeks, I can do it. Because I just go in and I threaten to arrest the judge and of course I'll see, right? But it's only kicking a can down the road for 4 or 6 weeks. Criminal's a different thing. And when I've gone in there, the barristers come up to me and say, and we've had conferences with them, and they said, well, what qualifications do you have? I said, well, more qualifications than any of you. So I've successfully represented myself in the Crown Court in front of a jury. Have you ever done that? Have any of your mates ever done it? Have any of the barristers done it? Have any of the judges done it? And they'll say no. And I know why they say no, because unless you're a nutter,
they say that anyone who represents himself in a Crown Court has a fool for a client. That is part of their policy. So when I say to them, well, I've actually represented myself. Now, let's look at that. Imagine you're a person who doesn't trust the legal profession. You don't trust them. You think they're all a crooked mafia. What do? You want somebody who successfully represented himself in those circumstances to assist them. And that's why it was very important when Rooftop 7 got acquitted of that bullshit, which went on our expense, that, you know, we've got 4 of them guys representing themselves. And 4 of those guys have joined my club. Because I was in a club of myself, to be honest with you. And because 1% of people represent themselves in the Crown Court. And perhaps only 1% of them are acquitted. So it's a very unique little club. But it's a wonderful club because it means that we can actually reflect onto them. Okay, look, man, you know, we're not part of you, and we've done this, and we've done that, and we've been successful. And so it empowers us. And so anyone who successfully represents himself in the Crown Court is in a different league. And I don't say that, but we just mean we can then do things. We can group together, we can win court cases. So when someone like, in Tom's position, and again, Tom's case, brilliant. Tom was charged with assault. And he was found not guilty of that. And we all thought when the judge put Craig and Mark's case and Bear's case up to the Crown Court, that the judge was stitching everyone up because he said conspiracy to commit criminal damage. Again, you know, overanalyzing things, but maybe he wasn't. He found Tom not guilty of assault. And maybe by saying conspiracy to commit criminal damage, you show the ridiculous nature of the charge that had gone, knowing that no judge could juggle that to the limit. I mean, I've been involved in cases for the last 30 odd years, right? And I know that I've never known anything where there's been more than one person representing himself in court. Because I know it just falls apart. Because they say, oh, you can't say this, you can't say that, and then the jury might say, oh, the judge has told me not to say this. And all of a sudden there's a mistrial. You know, the whole thing falls apart. And what you've got to realise is jury notification. So I know Michael and I've gone on about a lot. Jury notification. We're entitled to create perverse verdicts. Perverse verdicts. That's what it's all about. That's what it was all about. You know, what was his name? The guy in Newgate Prison.
David's case.
That's what it's all about. That's what, in fact, the guy who did this in the Old Bailey years ago, that's the first thing he read out. He said, in this very courtroom, this was Newgate Prison. And the judge tried making you guys find, I'm telling you I'm guilty, but I'm saying to you, find me not guilty because it's a load of bollocks. And you are the jury, you're the power in this court, not that judge. So it's very, very poignant. And we've got to the point now, where are we? We're in Nottingham. Again, a group of people. We're a bunch of psychos, are we? I don't know, what's going on? We're all in a room, and unfortunately, there don't seem to be many new faces, but I know outside there are loads of new people on this. You know, I get phone calls all the time, people track me down, hunt me down like a dog. You know, a lady ringing me up and said she's 66, she's just paid her mortgage off because her brother's relative died, and she paid the mortgage off, and are they going to steal my house and stuff like this? And we're in a new renaissance. We really are. We really are. This is what's going on. And we know it's like the French Resistance or something in the old films, isn't it? We've got the Stasi out there. We've got Stasi going on against us all day, every day. So let's move on. Yeah, subject matter jurisdiction, what Rob was saying. Yeah, I mean, it's essential. If you're in a parking ticket tribunal, and all of a sudden they brought in a murder charge against you, whoa, hang on, you're dealing with this. And this is going on every day. Yeah. But if you sort of consent, oh yeah, you can deal with this. This is what people do. People plead not guilty. I'll go back to that. Don't plead not guilty. I mean, if I'm at home and there's been someone killed over a house on the road and there's a knife and my fingerprints on it in my bin, right? There is a case to answer. And if I went to the magistrates court back in the 80s and 90s, they just said, well, there is a case to answer. There's your fingerprints, you refused to comment to the police, and it was in your bin. So there was a case to answer. So you would, in those circumstances, possibly plead not guilty. But I may have on my passport the fact that I was in Australia when that happened, but I don't talk to the police anyway, so I won't even bother mentioning that until they bring it to trial. If nobody in trouble, I don't talk to the police, so I think they're a bunch of criminals, but actually I was in Australia at the time. Oh, why didn't you tell us then? Well, I don't have to tell you that. We're not living in corpus juris, we're not living in France, we're not living in Napoleonic law. I know you'd like us to, but we're not. And that's the point, and that's what I do, right? Okay? So I mean, I know that a lot of people don't get me in some ways, because I could quite easily get myself out of things and not get arrested, but it doesn't really matter to me. You know, that's just me personally. I might be mentally ill, I mean, maybe someone will psych me up, but that's the way it is. Okay, well, let's do it then. Do it. And this is where we are when they arrested me the other night. Because it's comical, the way the machine tries to fight you. And I'm really happy that I'm able to give it back right now. Because years ago, I wouldn't have. You know, years ago, I've been arrested for things I didn't do, not very often, but I have been arrested for things I didn't do. And it's like, oh, you know, it's like paying your taxes. You know what I mean? But I mean, I've always tried to be a decent guy, and I've always thought, you know, we all look after each other. But I mean, if it was banks, if it was the government, you know, they're fair game. So when the other night, that my house was surrounded by a load of police. Sunday night, we had the grandkids all weekend, and I was knackered on my trampoline, and I was worn out. I went to bed about 8 o'clock, and we were always banging, and we saw all these torches at the window. And, oh yeah, we know the score, because they've been good regular to me, to a certain extent. And so, bang, 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 and then they're trying to get the keys out, and trying to put the hand through the cat flap to take the keys, you know, and all this. So you just, normally I would just ignore it. Right? Just ignore it. Because they're trying to gang stalk me. And gang stalking is a terrible thing. And gang stalking is going on with a lady called Carol Woods. I don't know, who knows with the Carol Woods story? Do you know what I mean? Gang stalking, I've seen it, man. I've had a woman who lives out in Hereford, just outside, who rang me up because every morning when she went out of the house to the kids to school, she came back and there was a human excrement on her carpet where her fire is. And all the family thought she was mental, everyone thought she was mad, even suggesting it. And they gang stalked her. And that's what gang stalking is. So gang stalking can happen to any and all of you, and all of us, right? Very easy, right, to look at, right? Most of the people gang stalking, you don't know what they're doing. So I'm in charge of the police, and I'm a serious Freemason, and there's a target. Michael, he's a good target. Michael's a target. So what we do is he lives in a little cottage in the country. We'll hire a cottage on the corner. We'll get a load of ex-police and ex-military, usually retired, get them there in cycling gear, and we'll say, Tom, here you go. You're going to get 50 quid a day for this. Stay in there for a month and cycle around. And every time he comes out of the house in the car, they claim that, oh, you almost run us over. And if there's a local pub, they go, oh, that guy's a bit malicious in his car. He almost runs us over every morning. They set little fires. And they don't know what they're doing. Now, there's a police helicopter over your house every night. Well, 2 nights a week. No, he doesn't know. He's just told, he's given coordinates. Sit over there for 10 minutes. But you know something. Now, when you start trying to explain all this stuff to people, it sounds like you're mental. And they've been doing this to us for years. Right? Gangs, I come from Hereford. So Hereford is where the SAS are based, right? Trust me, right? If we were in Iran, it would be the Republican Guard tank. Yeah? And they connect everything to do with anything is urban terrorism. They have done since the 80s. Right? So, and that's what they do. This is part of the game they're doing against us. But there's no need to get depressed about any of this stuff. Because we're exposing it and we're digging it up. So when they came around the house overnight and they arrested me, they surrounded the house, torches, giving it all that. So I came down into the conservatory area, so I said, what's the problem? And the inspector, with all the claims around, so he said, I've got a warrant for your arrest. I said, great, show me the warrant. Oh, I haven't actually got the warrant with me. Now, this isn't a civil thing. This isn't like, you know, one of your fake bailiff shit. This is a criminal thing now. They're trying to put me in custody. Well, he hasn't got it. Okay. So I read, which again, yes, anyone can do, the Criminal Procedural Rules, section 13.5, execution of a warrant. Again, don't use this in civil. This is a criminal procedure. The person who executes a warrant must explain in terms the defendant can understand what the warrant requires and why. He is unable to do that. B. Show the defendant the warrant, if that person has it. He was unable to do that. C. If the defendant asks, arrange for the defendant to see the warrant. So I said, okay, I'll go with you. I'm presuming that you're a trustworthy guy and you'll have the warrant. Of course, when we got to the police station, no such thing. So when I get to the police station and I get to the charge desk, the first thing I do, which again, use their own acts, use their own bullshit against them, yeah? Because then this is when it's like an earth in spuds. This is when we dig them up. Yeah? It's when we dig them up. If we're shouting common law all day, they don't give a shit, right? If they're able to expose them inside their own act. So then I read, which I presume you all know, Section 26 of the Criminal Justice and Courts Act 2015, which says corrupt or other improper exercise of police power and privileges. A police constable listed in subsection 3 commits an offence if he or she exercises the powers and privileges of the constable improperly and knows or ought to know that the exercise is improper. And 2, a police constable guilty of an offence under this section is liable on conviction, on indictment, to imprisonment for a term not exceeding 14 years. So I said that to the cop who's down at the police station. So I want to see the warrant. Simple, isn't it? Put in the room. End of. So I thought, okay, normally I don't use the duty solicitor and that, but I thought, okay, well, I'll use the duty solicitor to make a record of what's going on. So, duty solicitor. Duty solicitor wouldn't see me.
Yeah.
Like they got one on the phone from Bernie, which was very sort of thing. I said, look, I've never been arrested, I've never been interviewed at a caution, I've never been charged, I've never been bailed, yet I'm here for failure to surrender bail. So where are we? Well, this all sounds dodgy. I said, well, it sounds dodgy, I'm in custody. So, police officer got nothing. So they said, look, at 8:30 you'll be shipped out to Welshpool. Now, back in the day, 80s and 90s, what would have happened is a couple of detectives probably would have got me in a car, handcuffed me, in a Vauxhall Astra or something, a diesel, whipped me over to Welshpool, and that would be the end of it. And they took the piss out of me and the whole journey and all that. But none of that happened. In the morning I was woke up with a cup of tea from the reliance officers, because of course, you know, you've got reliance work inside the police station, not the corporation. Oh, cup of tea, guy. You know, okay, oh, thank you very much. What's the time? They said, oh, 9:30. So well, I'm supposed to be in Welshpool in half an hour. Oh, well, of course, they're busy. And they're busy? You know, they're busy. I'm fucking busy in here. Do you know what I mean? Anyway, not moved out, kick off about it, what can I do? You know, I've recorded it with the duty solicitor, etc. So I get pulled out the cell about 11, and they said, oh, we're not going to Welshpool now, because there's too many people going there apparently, by the sounds of it. They're going to Aberystwyth. Well, if they're going to Aberystwyth, why? Because I said, I demand to be put in front of the Crown Court, because I want to take a writ of habeas corpus out. Well, immediately. For myself. He said, well, we're going to take you to Aberystwyth. So, of course, 3 or 4, to start with, guys came in for G4S, and they ended up there working for this company called Civica. Well, it's a bit like Capita, you know, all these companies, okay? So, they put me in custody, they handcuffed these private individuals, they're all nice lads from Birmingham. Along the journey, I was sat in I got put in a sweatbox. I don't know if any of you know what a sweatbox is. But yeah, big metal aluminium thing. You're in a tiny little place like that. The foot slope is on a slant, so you're really uncomfortable. You've got absolutely no seatbelt, nothing. So you're bouncing around in plastic and metal. And of course they took me, last time I had that was in the 1990s, and I went from Wormwood Scrubs to Lashmere House down in Surrey. About 20 miles. This was about 110, 120 miles along the valleys and all that up in there. Hideous journey, right? So I was taken on this journey and presented at Aberystwyth. Well, the funny thing is, when we got to Aberystwyth, they didn't know where to go. It took them 40 minutes. Now Aberystwyth isn't big, right? But bless them, they didn't know where to go. So I was saying, pull over. And they were asking people on the street, and I was saying, look, they're probably tourists. Ask someone in a fucking shop. I was shouting from the door. they didn't have a clue where they were. But I said, go into a shop and ask someone who works there. When they did take me into Aberystwyth Magistrates, I was shocked. They took me to a brand new marina. And when I went there, I mean, Mark and Peter and Tom were all there. It's amazing. I was in the dock, and eventually, and I was surrounded by yachts and absolutely proper maritime law. So I'd seen the duty solicitor there, and I'd said, look, I've never been arrested, I've never been interviewed in a caution, I've never been charged, and I've never been bailed. So how can I be here for failure to surrender bail? And he agreed with me. Oh, well, there must be some error, right? Well, unfortunately, it was me that they'd done the error on, right? Because under identity law, which is what Rob was talking about, in the criminal remit, you talk about a case called Turnbull. So if anyone's ever arrested, because it's very hard to prove. I mean, look, I've been in Lance for years, but if there isn't a film with me and you on it, you try proving it. You try proving that you know somebody.
That's the Turnbull principle about identification.
Turnbull, it's called Turnbull.
That was named after me.
Yeah, oh right.
That was my case.
Oh right. Well, Turnbull.
Identification.
Oh right, well, Turnbull's identification. So it's Galbraith, in no case to answer. Inside their own realm, you don't do. And it's Turnbull inside the identification. So, of course, I said to the magistrates, right, I've never been arrested, and they didn't dispute it. So, what have we got? You know, we've got a guy that's been arrested, dragged halfway across Wales in a little van, blah, 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 all that. So, I went to the police station on Friday. Was it Thursday? Days ago.
Friday.
So, I went there to make a complaint. So, part of the complaint is this, now, because there's a wonderful guy I know who's got a printing business, and him and his wife, they live in, she lives in England, he lives in France, because they had terrible trouble with the establishment, and he's involved in consumer law. So he pointed me to this, the Consumer Risk Act 2015. And what he said is that they failed to make an assessment based under that act. Now you think, oh, look, I'm going to kidnap me and all that. But let's look at it, because what we're dealing with indemnity, and we're dealing with insurance for these captures. So they failed to make an assessment under that act, right? So they're a service provider, and under this act, it's got an act of royal assent, right? It states that this act places powers removing all vagaries over all regulators and authorities with no defined exceptions, including acting consumer enforcers. So what that means is they're providing you a service, but if they're providing you a service, when I went to the police officer in the station, I said kidnapped, and all the usual ones I said to him, but I also said that at the moment they arrested me and didn't have the correct paperwork, they were under an obligatory statutory duty to make sure that paperwork was correct. And of course it hasn't been, because you haven't produced the documents. When you took me into custody, you then transferred me to a private corporation who had sole responsibility and dragged me across Wales. If I was put in that metal death trap and we'd had an accident, I wouldn't have been insured, because insurance and indemnity is no good with acts of God and criminal acts. And if they've taken me away and they aren't able to produce the documents to support the merit in what they're saying, it's been a criminal act. So the copper jumped on this, you know, his sergeant brain understood what I was saying. But, so we're looking at all this stuff, you know, and again, sometimes the most obvious aren't the most obvious. We know they've got to be insured, we know they've got to have indemnity, we know they've got to be indemnified, and I've talked for years about this indemnity situation, because you've got to inform your insurers, even if there are circumstances that might give rise to a claim that have no merit. Simple as that. Otherwise you're not insured. So when you notify these characters of what's going on, and they carry on irrelevant, if they haven't notified their insurers, then they're not insured. So that was where I was put in that situation. rather than just going down saying it's kidnapped, done all through prison, blah, 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 blah. So, we'll move on. Also, there's an alternative dispute resolution directive in July 2015, which is worth, if anyone researching it, is worth getting into. They've got to offer an alternative dispute resolution from July 2015. And if you put that in with the October 15 Act, then it locks them into a position. Okay? Why? Because again, places powers, removing all vagaries of all regulators and all authorities. They're claiming to provide us a service. We're their customers, right? So we want good customer service. Right? We don't want to come in with fake documents and transport us halfway across the country and putting our life at risk, do we? So, right, okay, yeah, so, I mean, I can basically finish off here, really. So otherwise I'll just go on all night, right? So,
Yeah, go on.
oh, yeah. So, I mean, the funny thing is, right, okay, you know, it's just the perception of things, and times change and things change, right, okay? I remember when I was a kid and I left school, and you know, I wasn't very keen on getting a job, you know, and you know, I was just keen on doing what I wanted to do. And I continued in that vein for 25 years after. But, people say to me, what do you do for a living? You remember that? In the old days, you'd say, what do you do for a living? Yeah. And I used to say, I breathe. That's what I do for a living. You know, I'm not some plumber. I breathe, you know. And nowadays it makes more sense to me than it did then. I didn't even know what I was saying then, but I do now. So anyway, chaps, listen, we're all here, and even if some of you in a couple of years' time think we were in Derby or Leicester or it didn't even happen or whatever, because we don't get to that position, right? Okay, and they'll start claiming it's some sort of Alzheimer's and we're all mentally ill and all that. Okay. Bottom line is this, right? If they charge you with any criminal offence, right, okay, I know the civil court is shit. If they charge you with criminal offence, you hold them to strict proof. That's the expression. You hold them to strict proof. You hold them to strict proof. If you say nothing to them, then under identity it becomes Turnbull. Under no case to answer, it becomes Galbraith, right? You hold them to strict proof. Now, that is the way to go, because what's happening is they're making up these charges as they go along. You end up, I mean, you just go capture your house back, and all of a sudden, you're nobbled for something. You hold them to strict proof. It's not you to prove that you were or you weren't there. Identity, as Rob was saying, is an important issue. You try proving that you know someone. If you went to school with someone, right, even, you try proving you know them. No, mate, oh, I don't know, I can't remember him. It's very, very hard to prove. Now, they've been using these tricks against us, so we've got to reverse that back to them. So when they said that the old-style commitments were not removed, but hidden in the 90s, we weren't able to use them anymore, so all the checks and balances went out of the system, we've got to reintroduce them. The way we reintroduce them is no case to answer. And finally, what happened on that day, whether it was coincidence or whatever, the day I was dragged into court, and luckily I've got good friends like Mark and Peter and Tom, and they came over to the court and they came over to support me and to get me out of the place. The case before was a burglary case, as you've heard said. There was, I think it was 2 or 3 burglars, and the lawyer had stood up and said there was no case to answer. And those guys got removed from it, and the guy who pleaded not guilty was found guilty. You don't plead guilty to something that hasn't happened. You know, if there has been a burglary over the road and the safe's been stolen, and all that, and your fingerprints are found on a cup outside and your car was seen, well, there might be a case to answer. But if you know the guy has actually done the job himself, and done an insurance job, and you know him personally, you don't plead not guilty to something they can find you guilty. If new evidence comes to light, then they can charge you, right? So we've had probably 12 incidents since then. No case to answer. So I have no case to answer. I salute you all for being here. And
in association with GetOutOfDebtFree.org.